Our next speaker will be Peter Leff and then David Cadella. Welcome. Good afternoon.
Good afternoon. My name is Peter Leff of O'Donnell, Schwartz & Anderson, PC, General Counsel for the Graphic Communications Conference of the International Brotherhood of Teamsters. We represent over 60,000 employees in the printing and publishing industry in America, and we are part of the International Brotherhood of Teamsters, which represents 1.4 million hardworking men and women across the United States, Canada, and Puerto Rico. The Graphic Communications Conference of the International Brotherhood of Teamsters commends the members of the National Labor Relations Board for bringing the National Labor Relations Act into the 21st century and for proposing reasonable, predictable, and uniform rules for the conduct of representation elections. It is undeniable that the current system fosters uncertainty and chaos. The parties are left in the dark as to what issues will be raised at a pre-election hearing, when those issues will be resolved, and most importantly, when an election will be held to determine the desires of employees for union representation. It is in the interest of both unions and employers to know the date of an election as soon as possible. The board's attempt to take the uncertainty of scheduling a date for a representation election out of the equation is laudable and will provide unions, employers, and employees with much-needed guidance and predictability as to what will occur from the filing of a petition for an election to the counting of the ballots. As recognized by the board, the biggest roadblock to predictability in the scheduling of a date for a representation election is the unnecessary and often unwarranted pre-election litigation that bogs down the system and prevents the scheduling of an election. Once a petition has been filed, most, if not all, eligibility and unit inclusion disputes can be resolved after the unit employees have cast their ballots. The board's proposed rule deferring the resolution of all disputes concerning the eligibility or inclusion of individuals who constitute less than 20% of the proposed unit until after the ballots have been cast is an important step in the right direction to prevent disputes from delaying an election. Nevertheless, the 20% rule does not go far enough. Because delaying elections with pre-election litigation injects uncertainty and delay into the process, once a legitimate question concerning representation has been presented, no issues involving eligibility to vote or inclusion in the unit should be litigated before the election, regardless of the percentage of employees involved. Let me give you an example from my experience. On November 18, 2003, Local 527S of the Graphic Communications International Union filed a petition to represent the 69 employees who bagged and delivered the Atlanta Journal-Constitution newspaper at the employer's Cumming, Georgia facility. The employer challenged the appropriateness of the single facility unit, asserting that the only appropriate unit was all 3,800 plus employees in the Atlanta Journal-Constitution circulation department located in 70 facilities covering an area of 58,000 square miles. Despite the board's single facility presumption and the fact that the board has never denied the appropriateness of a single facility unit in favor of an integrated unit covering so many facilities over such a vast area of land, a six-day hearing was conducted over non-consecutive days. On January 23, 2004, the regional director directed an election at the single facility Cumming location. And finally, on February 6, 2004, a representation election was scheduled for February 17, 2004, 91 days after the petition had been filed. There was no reason to delay this election while we litigated the appropriateness of the petition for a single facility unit. There was no compelling reason why the appropriateness of the petition for unit could not be adjudicated after the election. The ballots at the employer's Cumming, Georgia facility could have been impounded while the parties litigated the appropriateness of the unit. If the employer's challenge was denied, the ballots would have been opened and counted. If the challenge was upheld, the union would have walked away because it had nowhere near the required 30% of petition signatures from all 3,800 circulation department employees. There would have been no harm in deferring resolution of this unit dispute until after the election. However, as a result of pre-election litigation, almost 3 months of uncertainty elapsed before the election was scheduled. Thus, the 20% rule is a good start, but does not go far enough to avoid delay over issues that could be deferred until after the election. I fear that employers will take advantage of the loophole inherent in the 20% rule by arguing, legitimately or otherwise, that additional employees that comprise more than 20% of the petition for unit should be included in the petition for unit. An employer should not be able to delay an election merely by asserting that employees of other facilities and other departments should be included in the petition for unit. These eligibility and inclusion issues can and should be decided after the ballots have been cast. Therefore, I propose that the board drop the proposed requirement that eligibility or inclusion disputes be deferred only if they involve less than 20% of the petition for unit. Instead, I suggest that the board revise its proposal so that once a question concerning representation is presented, all disputes concerning eligibility or inclusion of the individuals into the unit be deferred until after the election has occurred, regardless of the impact on the unit. Can I make one more comment, please? Finally, none of this has anything to do with the employer's free speech. These rules in no way limit an employer's free speech or its right to challenge the appropriateness of a petition. At the present time, if no issues are raised at the pre-election hearing and the parties agree to a stipulated election agreement, the election is set within a certain time frame. Nobody has ever claimed that this time frame is so short that it deprives an employer of its free speech rights. All that these proposed rules seek is to ensure that all petitions are scheduled for an election within a reasonable time frame. By instituting these rules, employers, unions, and employees will know from the beginning when a hearing will occur and when an election will be held. All issues challenged in the petition will be dealt with in due course after the balloting. The predictability, uniformity, and certainties of these rules will benefit everyone involved in these elections. Thank you.
Thank you, Mr. Leff. Other questions?
I've got a question about your example, a statutory question and then a practical question. The statutory question is, it seems to me that there is at least a statutory argument that we could not do what you propose. That is, the statute says that we need to hold, if a petition is filed and there's probable cause to believe that there's a question of concerning representation, we need to have a hearing to determine if there is a question concerning representation. And that suggests that you have to determine that there's a question in an appropriate unit. I take it the employer's argument in your case was a single facility is not an appropriate unit.
That's correct.
I wonder if there's a practical solution, which is the one proposed, and whether it would have worked in your scenario. That is, you have a presumptively appropriate unit. The rules propose that if party argues that presumptively appropriate unit is not appropriate, that they have to make an offer of proof. So prior to your 6 days of non-consecutive hearing, under the proposal, you have an offer of proof, and the hearing officer would say, this is a single facility, presumptively appropriate unit. You said this and that, but even if you could prove it, that's not going to be sufficient, so we're going to close the hearing. Would that have been a practical solution in your situation?
If it could go that way. I mean, again, our main goal is certainty in the election and not allowing anything to delay the date for election. I think that the employers may argue, look, we want a full and fair hearing on that. And I don't have a problem with that so long as it doesn't delay the election date. If you want to do it after, fine. And the union takes a risk by petitioning only for that small unit. If the employer turns out to be right, there's no representation rights. If there are issues that the hearing officer can decide beforehand that are very clear-cut, if the union tries to put a general manager into the unit and that person is so clearly a supervisor, the hearing officer at a pre-election hearing can summarily deny the request. I don't have a problem with that so long as we don't have to have a full-blown hearing and a 25 to 30-day wait period, which pushes off even the scheduling, if not the date of the election. So I leave it to you all to determine the best way to resolve these disputes, whether some can be resolved before or they all have to be resolved after. What I think the goal is the setting of the election date as early as possible, whatever time frame is adequate to allow employers and unions to give their free speech, and then doing except in the most exceptional circumstances, not messing with that election date.
Any further? Thank you very much.
Thank you.
Appreciate it.